Hi everybody, good evening and welcome to Thorough Newspaper Analysis. Now this is the video for the 27th of June 2024. Now let's proceed and have a look at the pointers of discussion for the day. So first of all, in the editorial segment, we have an Indian Express article to discuss. And this article essentially is with respect to the arrest of the Chief Minister of Delhi, Arvind Kejriwal, by the CBI. Now this is an interesting twist in this entire matter. If you remember, I believe just in the TNA for the day before yesterday, we covered how his bail was stayed by the Delhi High Court in the matter of money laundering. So we'll discuss this matter shortly. Secondly, we talk about the news updates for the day, and this is going to be followed by the last segment of legal news. So without further ado, let's start and let's first have a look at the title of this article. It is, why has the CBI arrested Arvind Kejriwal? And how is its case different from that of the enforcement directorates? So let me give you a context to it. If you remember, just in the other article, we discussed how there was a trial court which granted Arvind Kejriwal bail in the money laundering matter very recently, in fact. And as a result, the enforcement directorate sprung into action and immediately it filed an application before the Delhi High Court seeking a stay on the operation of that order of the trial court granting him bail. Now, what was the plea which was taken by the enforcement directorate? It was that the trial judge failed to appreciate the material which was placed before it, which ran into thousands of pages. So the trial judge did not consider or did not peruse that material very clearly. And the Delhi High Court, in fact, agreed with the ED's plea and observed that the trial court showed a lack of application of mind, which should have been done. And the material which was available before the trial judge, it should have been considered before granting the bail. And as a result, his bail order was stayed. So this is the story so far that we discussed in our previous TNA. Now let's take upon what has happened very currently and recently. So ahead of the Supreme Court's hearing on granting bail to Delhi Chief Minister Arvind Kejriwal on Monday in the money laundering charges linked to the alleged liquor scam or the excise policy scam, a Delhi court on Wednesday, which is 25th of June, granted the CBI, the Central Bureau of Investigation, a 3-day custody of Arvind Kejriwal. So a judge, a Delhi court has granted the CBI 3-day custody of Arvind Kejriwal. Now, earlier, the CBI arrested Kejriwal and requested a 5-day custody of the AAP leader in a corruption case. The special judge, he granted the CBI permission to arrest him formally. Now, let's understand why is this case, if at all this case is different from that of ED's, and if yes, then what are some of the differences? So please understand, while the case which is investigated by the Enforcement Directorate, it investigates the alleged money trail, the money laundering charges. The CBI case, it will have to prove corruption and bribe taking by public servants. So the matter with respect to which the CBI has now taken charge, it pertains to corruption allegations, while the matter which is in the hands of Enforcement Directorate, of course, because that is the subject matter of Enforcement Directorate, it is with respect to the charges of money laundering. So in March, the ED arrested Kejriwal on money laundering charges related to alleged tainted funds and the use of those funds under Section 3 of the PMLA. The CBI had registered a case of corruption under the PC Act. PC Act essentially is the Prevention of Corruption Act. And this registration happened back in 2022, but it did not name Kejriwal as an accused in that particular case. In fact, this March, the March of 2024, when the ED took Kejriwal into custody, Additional Solicitor General, he had told the Delhi court that one need not be an accused in the predicate offense to be an accused under the PMLA. Now, what is this contention? Let's understand it. Please understand, predicate offense essentially is an offense which is, you can say it's a part, it's a component of a larger, of a more complex offense. So here essentially the counsel who was representing the ED is saying that money laundering, it was a stand-alone offense. It did not depend upon the existence of a prime, a main, a more complex offense. So money laundering itself is a stand-alone offense. It does not need or it does not depend upon the existence of another major main offense. In April, the CBI called Kejriwal for questioning, with his lawyers arguing in the court that he was treated as a witness and not as an accused. As of now, he has not been named as an accused in the corruption case. So then a question may arise in your mind as to why is he now arrested then? So while the CBI has always had the option of arresting Kejriwal, he would first need to gather the CBI would need to gather, some plausible prima facie evidence linking him directly to the alleged offense or the alleged scam. So his direct linkage to the alleged offense or crime of corruption, it should be proved, and it should be established by prima facie evidence or plausible evidence. So in the ED's case, the direct connection is under suspicion. They argue Kejriwal's role as both the Chief Minister of Delhi and also as the convener, the leader, or the face of Aam Aadmi Party, which creates a vicarious liability linking him to the alleged tainted funds. However, this is not an option in corruption case. Also, please understand bail under the PMLA. We already have discussed a couple of times section 45 of this particular law. So bail here is difficult to obtain. Why? Because first you have to give the PP an opportunity of being heard, and when the PP raises an objection to the release of the accused on bail, then thereafter the accused has to fulfill two twin tests that there is a prima facie lack of evidence stating that this person has committed the offense, and secondly, if released on bail, there is no likelihood of him repeating the offense or committing offense. So here, bail under the PMLA, it is difficult to obtain. So focusing on this ED's case allows for extended custody of the accused. Now let's understand how do courts grant bail in corruption cases. So an accused can move for anticipatory bail in a corruption case, and the grant of bail in non-bailable offenses, it is subject to judicial discretion. Unlike the Prevention of Money Laundering Act, which provides a separate legal framework for handling money laundering crimes, the Prevention of Corruption Act, it does not have any strict conditions for bail. Under the Prevention of Corruption Act, rather, an accused individual applied for bail through the normal procedure, which is given under the CRPC. However, since 2014, amendments require that the public prosecutor must be given a chance to oppose any bail application under this particular law. In 2019, while granting bail to former Union Minister P. Chidambaram in the INX media case, the Supreme Court underlined certain factors that are required to be taken into consideration while there is a decision on the bail application under this Act of the Prevention of Corruption Act. So here the Supreme Court said and made certain observations, and I would like to quote it out. So it said that the nature of accusation and the severity of the punishment in the case of conviction and the nature of the materials relied upon by the prosecution, then the reasonable apprehension of tampering with the witnesses or apprehension of threat to the complainant or to the witnesses, then reasonable possibility of securing the presence of the accused at the time of trial or the likelihood of his absconding. Lastly, the character, behavior and the standing of the accused and the circumstances which are peculiar to the case, then the larger interest of the public or the state, and similar other considerations must be taken into account by the court, which is considering an application for grant of bail under the Prevention of Corruption Act. So I hope this article, proves helpful for your understanding on this entire matter. And now we'll proceed to the national news category for the day. So in the national news, this is the first update. Ladakh achieves full functional literacy. The Lieutenant Governor for Ladakh, Dr. B.D. Mishra, he declared that Ladakh has achieved full functional literacy under the Ullas Nav Bharat Saksharta Karyakram. So this has been stated by the Lieutenant Governor for Ladakh that the UT of Ladakh, it has achieved its full functional literacy under the program which is called the Ullas Nav Bharat Saksharta Karyakram with over 97% literacy. The Ullas New India Literacy Program, it is a national literacy program which is running from 2022 to 2027, supported by the central government. It follows the goals of the National Education Policy of 2020 targeting adults ages 15 and above who missed out of formal education. It aims to integrate them in society, enhancing their ability to contribute to India's development. Next up is an update in the category of defense. So INS Shivalik, the Indian naval ship INS Shivalik, it departed from Singapore for Japan, and in Japan the place concerned is Yokosuka, and it is scheduled to participate in an exercise which is called the Japan-India Maritime Exercise and also the Rim of Pacific military exercise. Now, the Rim of Pacific, it reminds me of something. If you remember, at the beginning of this year, we saw a couple of news articles on how Japan is hit by a series of massive earthquakes. And this is, not a new occurrence. Japan is known to be a country with immense instances of earthquake. And the reason here is that we often understand something called the Pacific Ring of Fire, or the fact that Japan its location is such that there is collision of certain tectonic plates. So this is an area of, if this is something that interests you, you may go ahead and read on it. Now, INS Shivalik, it is in the Eastern Fleet of the Indian Navy. It's deployed in the South China Sea and the Pacific Ocean. This deployment, it is aimed at improving how well India's Navy, it can work with that of Japan's, the US Navy, and other partners in this exercise, which is called the RIMPAC, the Rim of Pacific Military Exercise 2024. Now, Ministry of Coal, it initiates India's first ever pilot project for underground coal gasification, and this has happened in Jharkhand. Please take a note of the venue of it. It becomes an important pointer of information. So, under the Ministry of Coal's guidance, the Eastern Coalfields Limited, it has started a new pilot project for underground coal gasification, and this has happened at the Kasta coal block in Jamtara district in Jharkhand. This is groundbreaking initiative. Why? Because it aims to revolutionize the coal industry by using underground coal gasification to convert coal into valuable gases like methane, hydrogen, carbon monoxide, carbon dioxide directly at the site. Next is also another important update. Om Birla, he is elected the Speaker of Lok Sabha. So the BJP MP Om Birla, he was elected the Speaker of the 18th Lok Sabha following the Lok Sabha election, the General Assembly elections that we saw this year. After Prime Minister Narendra Modi, he moved a motion saying that, Om Birla be elected as the Speaker of Lok Sabha. So the Prime Minister moved this motion. This motion was later adopted by a voice vote. And as a result, he is now going to serve as the Lok Sabha Speaker for the second time. Also, this was interesting to note around this time around, which was that there was another contestant who contested for this position, so to say, and this was the contestant was raised from the opposition. So Om Birla, he defeated India Bloc's candidate. His name was K. Suresh, and this happened via voice vote that we've already discussed. So this is also a very interesting update. In case you're interested in politics, I would ask, and you have time at your disposal, you may go about and see the live telecast of this entire proceeding on either Sunset TV or any of the news channels. Bharat Center of Olympic Research and Education launched. So the Bharat Center of Olympic Research and Education, it was inaugurated at the Rashtriya Raksha University in Gandhinagar. The center, it will serve valuable knowledge and data on Olympics, training methods, sports science, and athlete development. The venue of it is important. You may make a note of it. RBI appoints director on the board of Bandhan Bank after drops in profits. So the Reserve Bank of India, it has appointed a director on the board of private sector lender, which is Bandhan Bank. This bank announced that the Reserve Bank of India has appointed Arun Kumar Singh, who is a retired chief general manager from the central bank, as an additional director on its board for 1 year. Now, this has brought us to another segment where we discuss important updates on important days. So the first day concerned is the International Day in support of victims of torture. So every year on 26th of June, please note down this date, it is 26th of June. So annually, every year on 26th of June, the world observes the International Day in support of victims of torture. This day, if we talk about the historic context, history of it or the historic context of it, then this day, it was established by the United Nations way back in 1997 to raise awareness about the torture and show support for its victims. The goal of this particular day, it is the total elimination of torture and the effective implementation of Convention against torture and other cruel, inhuman, or degrading treatment or punishment. Another important day is the International Day Against Drug Abuse and Illicit Trafficking. This is a very important, day which creates awareness on a very pressing issue that needs recognition and acknowledgement by the entire world community. So the International Day Against Drug Abuse and Illicit Trafficking, or called the World Drug Day, it is marked on 26th of June every year. And this is to strengthen action and cooperation in achieving a world which is absolutely free from drug abuse. This year's World Drug Day campaign, it emphasizes that effective drug policies, it should be based on science, research, respect for human rights, compassion, and understanding the social, economic, and health impact of drug use. The theme, as far as that is concerned for the year, it is evidence is clear, invest in prevention. Now, with this, we come to the international segment for the day, and this is the first update here. I'm sorry, I think I missed one update. Okay. Frank Duckworth, the co-inventor of DLS method, passes away at the age of 84. Frank Duckworth, who is the co-inventor of DLS. DLS is the Duckworth-Lewis-Stern method. He passed away at the age of 84. The method, it was renamed the Duckworth-Lewis-Stern method after the retirement of Duckworth and Lewis, followed by some modification by Australian statistician Steve Stern. This is another important update. NATO appoints outgoing Dutch Prime Minister as its next Secretary General. NATO has appointed Mark Rutte, the outgoing Dutch Prime Minister, as its next Secretary General amid the ongoing conflict in Ukraine. This is a crucial moment for European security. China has become the first country to bring soil sample from far side of the moon. So this is another important update in the category of science and tech and space. So China, it has become the first country to bring rock and soil samples from the far side of the moon as its Chang'e 6 probe returned to Earth. The near side of the moon faces Earth and it is mostly flat, while the far side faces away. And it is mountains and craters, deep depressions called craters. So in recent years, with the launch of missions by India, Japan, moon exploration, it has taken center stage. Earlier, countries like USA and Russia collected samples from the moon's next side, near side. European Union launches membership negotiations with Ukraine. This is another important update so far as the security of EU is concerned. So the European Union began membership talks with Ukraine 10 years after Russian troops took Crimea, aiming to prevent Ukraine from aligning more closely with the West, leading to tensions that escalated into war between the two neighbors. ISRO arm NSIL. What is NSIL? That we'll have a look at later. So ISRO arm NSIL, it signs a deal with Australian government for commercial satellite launch. The Australian government has signed a memorandum of understanding which is worth $18 million with the commercial arm of ISRO, the Indian Space Research Organization. This commercial arm is called New Space India Limited. Under this partnership, the Australian company Space Machines, it will launch a satellite inspection and the observation payload aboard ISRO's Small Satellite Launch Vehicle, which is also called the SSLV, in 2026. Now, this has brought us to the legal update segment for the day. And the first update is from Honorable High Court of Bombay. So the Bombay High Court on Wednesday dismissed the plea which was filed by 9 female students challenging the dress code which was prescribed by the authorities concerned of a Mumbai college, prohibiting the students from wearing hijab, niqab, burqa, stole, cap, etc. on the campus. The person who was representing the college, he clarified that this ban on religious symbols, it applies universally, not targeting Muslims alone. He emphasized that it aims to limit public display unless essential under the right to practice religion. Next update is from the Meghalaya High Court. So this is with respect to Section 145 of the CRPC. So the Meghalaya High Court has recently observed that a magistrate cannot base an attachment order under Section 146 of the CRPC solely on the inability to determine the possession of the disputed land if there was no evidence at all of a likelihood of breach of peace, which is provided under Section 145 of the CRPC. So what is the High Court said? The High Court has said that a magistrate cannot base an attachment order. So an attachment order cannot be made by the magistrate based solely on the inability to determine the possession of the disputed property. It has to be accompanied by the likelihood of the fact that there is going to be a breach. There is likelihood of breach, which is provided for under Section 154 of the CRPC. So if I were to give you a factual context of this case, the respondent filed an FIR, or to say the first informant filed an FIR alleging the petitioner's attempt to forcefully occupy her land. Now, the police investigation, it led to a report forwarded to the executive magistrate under Section 154 of the CRPC. Now, in this report, it was dealt with that the disputes over the land or water is likely to cause public unrest. The executive magistrate, after initiating the proceedings which are needed, so after initiating the proceedings, the executive magistrate ordered the attachment of the land which is in question, and this attachment order was passed under Section 146 clause subsection 1 of the CRPC. So the bench of the High Court noted while passing this order that the executive magistrate did not record any finding basing an existing factual situation to ascertain as to which party was in possession of the disputed land at the relevant point in time. If there is no direct evidence of any likelihood of breach, then the inability of the magistrate concerned to come to a finding as to which party is in possession of the disputed land. So if the magistrate is unable to come to a finding as to which party is in possession of land, so based on this fact alone, it cannot be sole ground for passing the order of attachment in the absence of likelihood of breach of peace. The name of this particular matter is Shri Minondro Areng versus Talika K. Sangam. So this has brought us to an end of our TNA. Thank you so much for watching. Have a wonderful day ahead.